The business can't be involved in illegal activity. That, I think, is sort of a hot topic these days. What I'm not saying is, well, we've got a bunch of organized crime figures that are filing under Chapter 11. That's not what I'm talking about. What I am saying is there are two kinds of businesses that, if they show up, create a real problem. One is the classic Ponzi scheme, which was named after a scam artist from the 1920s named Charles Ponzi. And the idea in the Ponzi scheme was people would invest. He wouldn't invest in anything, but the later investors, when they put money in, he would use that money to pay the earlier investors and just take the excess for himself. Well, eventually that sort of house of cards falls away, and people are left standing there in the dust out their money. And so that kind of business is generally thought of as a criminal enterprise. And so if there's a Ponzi scheme, that one's not going to fly. But more interesting to the current climate, companies that produce or are involved in the marijuana business. In the state of California, where I practice, marijuana use is legal. Though I don't recommend it. If you're not using marijuana, don't start. But in any event, there is legal marijuana in California. However, marijuana is not legal under federal statute. It is an illegal substance. And so the Bankruptcy Code, which is a federal statute, prohibits the plan using anything that is forbidden by law. So this is a topic of some heated discussion now. Can a marijuana business seek bankruptcy protection? Turns out this isn't just in Chapter 11, it's also in Chapter 7. But if you've got an enterprise that is a marijuana growing or marijuana dispensing business, then the source of the revenue to fund the plan is from a source that is illegal under federal law. So that is that's a pretty big problem there. And there is a Ninth Circuit case holding that a debtor was permitted to seek bankruptcy relief because the connection to the marijuana business was a bit attenuated. So that wasn't a problem in that particular case. But generally, that's going to be a problem. Now, with regard to the size of the business, there really isn't a size restriction. I will say if you've got a small business and your revenues are maybe $100,000 a year, your assets are something on that same order, and maybe you have debts of a couple $100,000, there is no point in getting involved in the complexity of Chapter 11 if there's a way around it. It doesn't mean you can't do a Chapter 11, but a small enough business, there may be other ways to address the issue, especially if it's a sole proprietorship, because Chapter 13 then can be used by the debtor to address these debts because the business and the debtor are really one and the same. When you have a corporation, that changes things a bit, but and there are strategies for dealing with that sort of thing. But the size is really not that important. You can have a small business. You can have massive businesses. I mean, GM some years ago did a Chapter 11. This Silicon Valley Bank is dabbling with Chapter 11. You can have massive businesses in Chapter 11, and you can have small businesses in Chapter 11. And you can have individuals in Chapter 11.